Welcome to Daily Justice Files.
Court is calling 2021 CR 9806, State of Texas versus David Kianis II. Could I have parties announced for the record for the state?
Jason Garrett, for the state, Your Honor.
Brian Kimbrough for the news.
Are you Mr. Kianis?
Yes, Your Honor.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you have a chance to review that with your attorney? Did you understand it?
I did, Your Honor.
Are you the same David Kianis II who was placed on deferred adjudication in 2021 CR 9806 for the offense of aggravated assault with a deadly weapon on November 16, 2022 for a period of 8 years? Is that you?
That is me, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 2, on or about the 28th day of April 2023 in Bexar County, Texas, the defendant David Kianis II to then their legally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
It's true, Your Honor. We'll waive the remaining violated conditions, Your Honor.
Any objections? Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
I do, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. And the recommendation for under probation is also the same, to deny the motion to do the adjudication of guilt and continue the individual on his deferred, and to have him enter the DDRF followed by outpatient and 180 days in sober home.
Is that what you're asking the court to do, defense?
It is, Your Honor.
All right, Mr. Kianis, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
David Kianis II.
All right, Mr. Kianis, why are you not being successful on this probation? And here you are back on the same day that I gave you probation, the 16th. So why are you not doing what you're supposed to do?
I don't have any valid excuses. I've been doing the best that I can out there, and I'm in a lot of the wrong places. I didn't pay my phone bill. I didn't have the available open opportunity for probation to contact me, and that's my fault. That's why I wasn't able to follow some of the conditions. But it's not something that I wish to continue doing. I just want the opportunity to be able to make this right. And
well, this is a case where the state wanted you to go to prison, and your previous attorney brought me medical issues concerning you, mental health issues concerning you. So I'm the one who gave you deferred. And instead, what you're doing is using drugs. And then I even tried to address the mental health issue, and I'm not taking it as true, but we're trying to get to the bottom of what's going on with him. I even had you go to the mental health initiative, and you're not doing that. You're doing nothing. You're just coming to me with your hat in your hand and saying, please don't revoke me. So I don't understand how things would be differently if I were to follow the agreement and not revoke you. So what are you doing?
I'm just trying to do the best that I can out there, and
But what does that mean?
I've had an unstable home environment, and I haven't been home as often because it hasn't been a very positive place to be.
Okay, well, how old are you?
36 years old.
All right, who are you living with?
My father.
All right, so obviously, maybe your father doesn't want you there, or you don't want to be there because you don't think it's the best environment. Am I right in that?
You're right in the fact that I don't want to be there. It's just there's drug usage in the house, and I don't want to get in trouble for that.
Okay, so why don't you have a place of your own?
I'm on disability. They take child support out. I'm not making enough per month to support myself.
Okay. Probation? I don't know what we can do with Mr. Kianis. Where is he going to be living? I mean, I know everybody said sober home, but
so I know that was a recommendation, and I had spoken with defense counsel about it. I mean, he would have to, for the sober living environment. I mean, that is something that is also requires payment, and it's like a rent. You have to rent a room. So, I mean, there's the financial obligation for that as well.
So does anybody know how much that costs?
I think it varies per house. So he has to, I had explained that they have to kind of apply to enter the sober living home. And then the sober living home has to be willing to accept him as a resident.
One probation violation, one admission of drug use, and a judge with the power to send this defendant to prison for 20 years.
Well, will Lifetime accept him?
I believe that they will accept him. I know that we had talked about some medical issues that he has. And so I had explained, even in an inpatient setting, I don't know what his medical limitations are, but we can certainly try Lifetime Recovery. And then maybe while he's transitioning out of Lifetime, maybe give him a referral to the reentry center, or maybe even recommend him to felony drug court.
All right.
That's another option that would have a lot of more frequent contact with him and some case management services.
All right. So I'll deny the motion, altering conditions, and it's to be Lifetime Recovery, followed by a referral to felony drug court with their dual diagnosis program. Is there anything else?
Nothing in the state, Your Honor.
No, Your Honor. Is there a lifetime recovery? Does that involve a process? And
Yes, and they will actually transport him from the Bexar County Jail.
that's fine.
All right. Is there anything else you need from the court to be successful?
No.
All right, we can go off the record. From here on out, you need to get in touch with your probation officer. You just can't be out here on probation and not really on probation because you're not doing anything. Otherwise, you could potentially be going to prison for 20 years. You understand?
I do, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Court is calling 2023 CR 7902, State of Texas versus Leonard Johnson. Can I have parties announced for the record for the state?
Zach Donovan, State.
Defense?
Cornelius Cox.
And are you Mr. Johnson?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Johnson, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor. Save for the fact that we'll be waiving and abandoning the enhancement.
Any objection? Mr. Johnson, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes,
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There are no applications. There's an affirmative finding of family violence. There's to be no contact with Barbara Ann Nichols Duncan. Did you understand that to be the plea?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, are there been any such motions?
Sorry.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offers states 1 and attachments.
Okay.
Mr. Johnson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State, have you talked to the complainant?
I have, Your Honor.
And is she aware of this?
She is, Your Honor.
And is she in agreement with this?
She is, Your Honor.
All right, defense, anything you wish to say on behalf of your client?
No, Your Honor. Just state the court followed the plea agreement.
All right, the court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's an affirmative finding of a deadly weapon. There's to be no contact with Barbara Ann Nichols Duncan. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Do not come back here again for this nonsense. Do you understand?
Yes.
She does not want to be with you. And again, I'm going to tell you this. If somebody has a new boyfriend, a girlfriend, that means that they don't want you. Or if it means that, oh, I still want you, but I want my boyfriend or my girlfriend as well, you have two choices. Either accept it or say this relationship is over. You don't get violent. You understand?
Yeah.
All right, good luck to you. All right, and what is the discovery issue?
The discovery issue relates to the medical file of the complaining witness at the VA hospital. I filed a motion to cover my bases. We can have the argument of whether or not the state has an obligation to get this under Brady and Big Window, but the long story short is that the VA requires a order from the court to release that information. So I was cutting out the middleman by including that.
All right, so this is what we're going to do. We're going to bring this back on November 30th.
Okay.
And at that time, I'll give you a jury trial setting. And at that time, we'll see where we are on the medical records.
Okay.
So state, if you can see, if you all have that, or if you all are going to object to this, then we'll take.
Yeah, I mean, if it's in our possession, we'll turn it over. If it's not, I don't think we're required to go and find it.
All right. So on November 30th, we're going to come back. And on that date, you will get your trial setting date, and we'll take up the issue of this discovery matter.
Okay. I guess I would ask the court if they could rule on, or if they could order.
Well, here's the thing. I know you want to cut out the middleman, but I like to do things where it's done as quickly as possible. Guess what? If the state has this, and we're very crowded in court today, if they have this, they're going to give it to you. So there's no need for this.
My understanding is they don't have it. It's in the possession of the VA hospital.
Well, let's find out.
Oh.
We'll find out. So we'll come back on November 30th.
All right. Thank you, Judge.
Who's the attorney for Annette Drago?
That's me, Your Honor.
All right. Today, an offer was due. Has an offer been tendered?
It has, Your Honor.
But before making that decision, Judge Boyd asks a series of questions that reveal a far more complicated story. Is this a case that deserves prison or one last chance?
And what I would like to do is get a plea deadline date for her to consider it. And then we can come back and tell you if it's going to be a plea or a trial.
All right. On Annette Drago, can you recall that back on the 30th as well? All right. Your plea deadline date is going to be November 30th. At that time, you'll need to let the court know whether or not you're accepting the offer. Do you understand?
Yes, ma'am.
Your Honor,
Yes.
I'm real sorry, but can we do it either 27, 20, 29, just because I'll be in Colorado.
Oh, what are you doing in Colorado?
Like every year I take my kid to Breckenridge, my wife.
All right, we'll put it on the 28th.
Perfect. Thank you very much.
And then before you leave, Dinah's thinking about that. So if you can tell her what you all do in Colorado.
I will. Yeah.
All right, thank you.
A lot of fun. Do sleigh rides and stuff. Really, it's fun.
Yeah, she wants to know where to go and what to see.
Okay.
All right, then with that, you're excused.
Thank you, ma'am.
All right, court is calling 2023 CR 8385, State of Texas versus Kevin Owens. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Orlando Castañon.
All right, the court is in receipt of a request to allow Mr. Owens to travel on November 20th to Sustainable Staffing located at 8008 West Avenue, Suite 2, from 8:30 a.m. to 3 p.m. for a job interview, and also to travel for a job fair on November 29th, 2023 at Southeast Education Center, 5230 Eisenhower Road, San Antonio, Texas, 78218 from 10 a.m. to 2 p.m. State, do you have any objections?
No, Your Honor.
All right,
Thank
it will be allowed. And once you sign the reset form,
Yes, Judge.
you're excused.
Okay.
After admitting the probation violation, the defendant leaves his future entirely in the judge's hands. Instead of focusing only on the failed drug test, Judge Boyd looks deeper into the defendant's mental health, unstable living situation, and ongoing struggle with addiction. Those answers become the key to the court's decision. In the end, the judge chooses treatment over prison, giving the defendant one final opportunity through lifetime recovery and felony drug court. But the message is clear: another mistake could mean years behind bars. If you were the judge, would you have given him another chance or sent him to prison? Let us know in the comments and subscribe for more real courtroom stories.